Members of the jury, you have heard all the evidence in the argument of counsel. It is now your duty to make a decision as to the appropriate sentence that should be imposed upon the defendant for the crime of first-degree murder. I'm going to send these instructions back with you so you don't have to take notes on these as well. There are two possible punishments: life imprisonment without the possibility of parole, or death. In making your decision, you must first unanimously determine whether the aggravating factors alleged by the state have been proven beyond a reasonable doubt. An aggravating factor is a circumstance that increases the gravity of a crime or the harm to a victim. No facts other than proven aggravating factors may be considered in support of a death sentence. The aggravating factors alleged by the state are: 1. First-degree murder was committed for financial gain, and 2. The first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. You have heard evidence about the impact of this murder on the family and friends of Teresa Sievers. This evidence was presented to show the victim's uniqueness as an individual and the resultant loss by Teresa Sievers' death. However, you may not consider this as evidence as an aggravating factor. As explained before the presentation of evidence, the state has the burden to prove an aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt, and you must not consider it in providing a verdict. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, a conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find the aggravating factor does exist. A finding that an aggravating factor exists must be unanimous. That is, all of you must agree that each presented aggravating factor exists. You will be provided with a form to make this finding as to each alleged aggravating factor, and you should indicate whether or not you find each aggravating factor has been proven beyond a reasonable doubt. If you do not unanimously find that at least one aggravating factor was proven by the state beyond a reasonable doubt, then the defendant is not eligible for the death penalty, and your verdict must be for a sentence of life imprisonment without the possibility for parole. At such point, your deliberations are complete. If, however, you unanimously find that one or more aggravating factors has been proven beyond a reasonable doubt, then the defendant is eligible for the death penalty, and you must make additional findings to determine whether the appropriate sentence to be imposed is life imprisonment without the possibility of parole or death. If you do unanimously find the existence of at least one aggravating factor and that the aggravating factors are sufficient to impose a sentence of death, the next step in the process is for you to determine whether any mitigating circumstances exist. A mitigating circumstance is anything that supports a sentence of life imprisonment without the possibility of parole, and can be anything which might indicate that the death penalty is not appropriate. It is not limited to the facts surrounding the crime. A mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may reasonably indicate that the death penalty is not an appropriate sentence in this case. It is the defendant's burden to prove that one or more mitigating circumstances exist. Mitigating circumstances do not need to be proven beyond a reasonable doubt. Instead, the defendant must only establish a mitigating circumstance by the greater weight of the evidence, which means evidence that more likely than not tends to establish the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you must consider it established and give that evidence such weight as you determine it should receive in reaching your verdict about the appropriate sentence to be imposed. Any juror persuaded as to the existence of a mitigating circumstance must consider it in this case. Among the mitigating circumstances that you may consider are: Mark Sievers has no significant history of prior criminal activity. Mark Sievers was an accomplice in the first-degree murder committed by another person, and his participation was relatively minor. The existence of any other factors in Mark Sievers' character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death penalty. Your decision regarding the appropriate sentence should be based upon proven aggravating factors and the established mitigating circumstances that have been presented to you during these proceedings. The next step in the process is for each of you to determine whether the aggravating factors that you have unanimously found to exist outweigh the mitigating circumstances that you have individually found to exist. The process of weighing aggravating factors and mitigating circumstances is not a mechanical or mathematical process. In other words, you should not merely total the number of aggravating factors and compare that number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or values by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular factor or circumstance. Regardless of the result of each juror's individual weighing process, even if you find that the sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to determine that the defendant should be sentenced to death. Once each juror has weighed the proven factors, he or she must determine the appropriate punishment for the defendant. The jury's decision regarding the appropriate sentence must be unanimous if death is to be imposed. To repeat what I have said, if your verdict is that the defendant should be sentenced to death, your finding that each aggravating factor exists must be unanimous. Your finding that the aggravating factors are sufficient to impose death must be unanimous. Your finding that the aggravating factors found to exist outweigh the established mitigating circumstances must be unanimous. and your decision to impose a sentence of death must be unanimous. You will be provided with a form to reflect your findings and a decision regarding the appropriate sentence. And that form is as follows. You have Section A. It says aggravating factors as to count 1. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the capital murder was committed for pecuniary gain. You will, once you have a unanimous decision, you will check yes. If you have a unanimous decision for yes, you'll check yes. If not, you'll check no. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the capital felony was a homicide. It was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. If you all agree unanimously as to yes, you'll check yes. If not, you'll check no. And if you check yes to at least one of those factors in A, then you'll move down to the next section, which reads, if you answer yes to at least one of the aggravating factors listed, please proceed to Section B. If you answered no to every aggravating factor listed, do not proceed to Section B. In other words, if the answer is no to both under A, that will be the end of your deliberations. Mark Sievers is not eligible for the death sentence and will be sentenced to life in prison without the possibility of parole, again, if both are no in A. B reads, sufficiency of aggravating factors as to count 1. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt in Section A, we, the jury, unanimously find that the aggravating factors are sufficient to warrant a possible sentence of death. If you have a unanimous verdict as to yes, you'll check yes. If not, you'll check no. If your answer in Section B is yes, then you'll proceed to Section C. If not, then your deliberations are complete. If you answer no to Section B, do not proceed to Section C. Mark Sievers will be sentenced to life in prison without the possibility of parole. C reads mitigating circumstances. One or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence. If the jury decides yes, you'll check yes, and if not, it's no. Then you'll proceed to Section D, regardless of your findings in Section C. D is eligibility for the death penalty for count 1. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt in Section A outweigh the mitigating circumstances established in Section C above as to count 1. If you unanimously agree, then you'll check yes. If not, you'll check no. If you answered yes to Section D, you'll proceed to Section E. If you answered no to Section D, do not proceed to Section E. Mark Sievers will be sentenced to life in prison without the possibility of parole. E reads, the jury verdict has to death penalty. Having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt in Section A, that the aggravating factor or factors are sufficient to warrant a sentence of death, Section B, and the aggravating factor or factors outweigh the mitigating circumstances, Section D, we, the jury, unanimously find that Mark Sievers should be sentenced to death. If you all agree, then the answer would be yes. If not, then you'll check no. There's a spot for the foreperson to sign and date the form or use their juror identification number and to bring it back with you once you have a verdict. If your vote on the appropriate sentence is less than unanimous, the defendant will be sentenced to life in prison without the possibility of parole. The fact that the jury can make its decision on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that a human life is at stake, and bring your best judgment to bear in reaching your verdict. When considering the aggravating factors and mitigating circumstances, it is up to you to decide which evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in making your decision as to what sentence should be imposed. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Did the witness's testimony agree with the other testimony and other evidence in the case? Had the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Has the witness been convicted of a felony? The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert opinion is only reliable when given on a subject about which you believe that person to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime hopes to gain more favorable treatment in his or her own case may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So, while a witness of that kind may be entirely truthful when testifying, you should consider his or her testimony with more caution than the testimony of other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve any part of the evidence or the testimony of any witness. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. These are some general rules that apply to your discussions. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your decision will be a miscarriage of justice. There's no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. Your decisions must be based only on the evidence that you've heard from the testimony of witnesses, have seen in the form of exhibits and evidence, and these instructions. Your decisions must not be based upon the fact that you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decisions. Your decisions must not be influenced by feelings of prejudice or racial or ethnic bias. Your decisions must be based on the evidence and the law contained in these instructions. In just a few moments, you'll be taken to the jury room by the bailiff. When you have reached decisions in conformity with these instructions, the appropriate form should be signed and dated by your foreperson. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case, and you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats or the front rail where they'll be guarded by the bailiff while you deliberate. Do not contact anyone to assist you during your deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. The exhibits will be sent into the jury room with you when you begin to deliberate. If you wish to see any other exhibits, please ask for them in writing. Again, I'll send back everything from the trial that I can, that is not a biohazard or a video or audio recording, and everything from this portion of the phase, the penalty phase, back as well. If you want to see anything not sent back or want to watch any of the videos or listen to any of the audio, by all means, or any of the biohazard materials, just let us know, and we'll bring you out, and you can spend as much time looking at them as you would like. I cannot participate in your deliberations in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. If you need to communicate with me, send a note through the bailiff signed by the foreperson. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. In closing, let me remind you that it is important that you follow the law spelled out in these instructions. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. With that, I will still ask our juror number 252 and juror number 446 to remain behind, our 2 alternates. I won't be sending you back. I do need to talk to you again. But to our other jurors, we'll let you retire. You can take your notes with you, and we'll send back the exhibits and the instructions and the verdict form. Please be seated. I want to thank both of you so much and for your time and attention over these past few weeks. I know it's not easy, and I can release you now that we've sent the jurors back. You are both welcome to stay if you want to wait for the verdict and leave with the other jurors. And if you want to ask the attorneys any questions, you can. They will not approach you and ask you any questions. But if you want to leave and you want to know what the verdict is and the recommendation, you can leave your number again with us. Just write it down on a pad, and my clerk, Michelle, will call you and let you guys know what the verdict is. And you're going to leave with my thanks, the thanks of both parties here today in the judicial system. You guys have any questions? Anything further with the alternates either side? So you're both free to go if you'd like, and if you want to stay, you can by all means. Yes, sir. Thank you both so much. I really appreciate it.
I do want to say something.
Yes, ma'am.
This experience has helped me in a lot of the things that I've dealt with and understanding what it takes to get answers, to get to the point to where you can be freed and, released from. It was a help, so I enjoyed it. I'm sorry for both sides, but it was a help to me. It was something that God meant for me to be a part of.
Thank you, ma'am.
Yes, sir.
Is that a note? Okay. Please be seated. We already have a note. Oh, do you need, here's the, Bill, here's the instructions and the verdict form. Thank you. Well, we'll be sending the rest back in a moment. Hold on. The note reads, Judge Kyle, can we have more than one copy of the instructions, please? Thank you. No objection to me taking those and Xeroxing them before?
No objection.
No objection.
Okay. We'll be in informal recess. Please don't go far and leave your phone numbers if you do, and I'll make copies of, you can have that though, of the instructions and I'll send them back.
Are they collecting their electronic devices?
They should be.
They're all out here.
Make sure they got
I
them
brought
all.
a bunch out.
Okay,
Thank you.
I'll be right back.
Yes,
12, right? Not 14.
right. Well,